Good morning. The Judiciary Committee will come to order, and without objection, the chair is authorized to declare recess of the committee at any time. Pursuant to notice, I now call up H.R. 3490 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 3490 to amend the Homeland Security Act of 2002 to authorize the National Computer Forensics Institute and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point. I'll begin by recognizing myself for an opening statement. The National Computer Forensics Institute serves a vital purpose in preparing state and local law enforcement to combat computer and cybercrime, and I am proud to support this legislation. The United States Department of Justice has declared that cybercrime is one of the greatest threats facing our country, and that cybercrime has enormous implications for our national security, economic prosperity, and public safety. The Justice Department has also stated that the range of threats and the challenges they present for law enforcement expand just as rapidly as technology evolves. With this in mind, the National Computer Forensics Institute serves the vital purpose of providing legal and judicial professionals a free, comprehensive education on current cybercrime trends, investigative methods, and prosecutorial and judicial challenges. The National Computer Forensics Institute is a 32,000 square foot facility located in Hoover, Alabama. This institute boasts 3 multipurpose classrooms, 2 network investigations classrooms, a mock courtroom, and a forensics lab. Special agents of the United States Secret Service staff the institute and work diligently training attendees in modern counter-cybercrime procedures and evidence collection. When the attendees leave, they take with them the critical knowledge and equipment required to conduct autonomous and thorough cybercrime investigations at their home agencies. Since its creation, the Institute has earned praise for its work in preparing America's law enforcement in how to deal with these important technology issues. Since its creation in 2008, the Institute has instructed law enforcement professionals from every state in the country and from over 500 different law enforcement agencies. Each professional educated at the Institute is a force multiplier for the Secret Service, and after successful completion of the program, the students can bring their new knowledge back to their local agency to inform their colleagues how to properly conduct computer forensic investigations. I firmly believe that for our nation to successfully combat the cybercrime threat, we must support legislation such as H.R. 3490, and I want to thank the gentleman from Texas, Mr. Ratcliffe, for sponsoring this important legislation. Authorizing the existing National Computer Forensics Institute in federal law will cement its position as our nation's premier high-tech cybercrime training facility and will help law enforcement professionals nationwide in their efforts to combat cyber and computer crimes. At this time, it's now my pleasure to recognize the ranking member of the committee, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee, H.R. 3490, the Strengthening State and Local Cybercrime Fighting Act, establishes the National Cyber Forensics Institute, NCFI, as an official federal program which will be managed by the Department of Homeland Security and operated by the United States Secret Service. I, along with the chairman, support this bill because it addresses a topic that is critically important to our country and this committee. First, cybercrime poses an enormous threat to national security, economic prosperity, and to public safety. The range of threats and the challenges they present for law enforcement expand just as rapidly as technology evolves. In fact, during the past decade, our federal law enforcement community has observed a significant increase in the quality, quantity, and complexity of cybercrimes targeting private industry, including our financial services sector. These crimes include intrusions, hacking attacks, the installation of malicious software, and data breaches that have exposed the personal information of millions of American citizens, as well as members of our law enforcement and intelligence services. To date, the National Cyber Forensics Institute has trained more than 800 state and local law enforcement officers and approximately 238 prosecutors. With this legislation, the Institute will continue to educate state and local law enforcement officers, prosecutors, and judges on current trends in cyber and electronic crimes investigations. And the Institute will train them on proper procedures to conduct these important investigations. Now, in addition, the National Cyber Forensics Institute will continue to work to protect our citizens' personal information from unwarranted government intrusion. By establishing national standards for conducting cybercrime investigations, the Institute will promote these important privacy interests. And finally, it's important to highlight the successful efforts that have already taken place to combat the ever-growing threat of cybercrime. As the operator of the National Cyber Forensics Institute, the Secret Service has demonstrated its prowess in pursuing cybercrime investigations. The Secret Service's investigations have resulted in over 4,900 arrests associated with more than $1.4 billion in fraud losses and the prevention of over $11 billion in potential fraud losses during the last 5 years. Cybercrime poses a significant threat to national security, economic prosperity, and public safety. And so I support this legislation because it will assist law enforcement in continuing to combat cyber and electronic crimes. I thank the chairman for this time and yield back the balance.
Thank you, Mr. Conyers. Before I turn to the gentlewoman from Texas, I'd like to take a moment to welcome and recognize my representative in the Virginia House of Delegates, who's here from Roanoke, Virginia, Chris Head, and his wife, Betsy. Thank you for joining us today. And now I'd like to recognize the gentlewoman from Texas, Ms. Jackson Lee, who is the ranking member of the Subcommittee on Crime, Terrorism, and Homeland Security, for her opening statement.
Mr. Chairman, thank you so very much. And I am excited about this bill. First, to thank my fellow colleague from the Homeland Security Committee. So I have 3 reasons thanking him. The second reason is to be able to thank the Secret Service for their stunning work of last week. Of course, they will say that they were doing their job, and that they will, and that they were. But I do think they are owed, along with law enforcement, a debt of appreciation and gratitude for the extensive security coverage that Pope Francis received from coming into the United States, both in Washington, D.C., New York, and Philadelphia. So I wanted to add my appreciation to them for their service. And then secondly, I'm excited about this new opportunity to ensure our concern and oversight dealing with cybercrime fighting. This Strengthening State and Local Cybercrime Fighting Act will facilitate the training of state and local law enforcement, prosecutors, and judges on cutting-edge issues in the fight to combat cyber and electronic crime by formally establishing the National Cyber Forensics Institute within the Department of Homeland Security. Every time I'm at home or engaged with individuals and businesses, the discussion of cybercrime comes up. Cybercrime is an epidemic that impacts individuals and institutions, both the public and private sphere, at all levels, local, state, and federal. Cybercrime poses a threat to our national, economic, and homeland security but individual cyber threats may not always fit within the priorities of our federal law. For those of us who've served on the Homeland Security Committee for a number of years, since, in fact, 9/11, we know that we've discussed the over 85% of the cyber world in the private sector, and therefore they are certainly impacted. Often the task of investigating and prosecuting cyber offenses falls on our state and local enforcement prosecutors because it deals with the private sector, the private landscape. The efforts of these dedicated public servants are frequently limited or impeded by lack of funding and resources, training, particularly inadequate training, antiquated equipment, and technology. Since 2008, the NCFI has stepped up to fill in this gap and as a result made our communities much safer. NCFI provides state and local law enforcement agencies tuition-free, comprehensive education on current cybercrime trends, investigative methods, and prosecutorial and judicial challenges. I hope this legislation will be able to get to the President's desk so that it can build on what it has already done, trained over 500 state and local police officers, prosecutors, and judges from all 50 states. And in some advanced forensics and network intrusion courses, NCFI has provided students at no cost all hardware, software, and licenses necessary to conduct such investigations. I believe that providing students the same equipment as the U.S. Secret Service agents, NCFI facilitates increased collaboration and communications between local offices and federal agents. If not for the work of the NCFI, many forensic investigations would not have been conducted and many complaints would have been forwarded to overburdened federal agencies unable to pursue them. Congratulations to the Secret Service again. They have an excellent track record, and therefore this legislation covers a number of aspects of that, providing that resource to local and federal, local and state authorities. And I believe that the NCIF's training and education programs have made America safer, and as well the idea of the threat of cybersecurity taken very seriously now is in the eye of the storm. And we are engaged in that storm, looking to be victorious over this dastardly epidemic that is plaguing this nation. Let me conclude, Mr. Chairman, by indicating that you may be aware that a task force on terrorism has just finished its report indicating the number of foreign fighters and those that have left the United States and potentially coming back to the United States. As I conclude my remarks, I'd like to introduce into the record H.R. 48, which is my legislation on the No-Fly for Foreign Fighters Act. And I would look forward to this committee, my colleagues, the ranking member, Mr. Conyers, the chairman, Mr. Goodlatte, working together to be able to address this legislation. It was referred to judiciary. With that,
if the gentleman would yield,
I'd be happy to yield.
We certainly share your interest in this subject matter, and we'll be looking forward to having further discussions with you about that.
Thank you very much. With that, Mr. Chairman, Mr. Ranking Member, I yield back my time.
Chair thanks the gentlewoman. I now recognize the gentleman from Texas, Mr. Ratcliffe, for the purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 3490, offered by Mr. Ratcliffe of Texas.
Without objection, the amendment in the nature of a substitute is considered as read, and Mr. Ratcliffe is recognized to explain the amendment.
Thank you, Chairman Goodlatte, Ranking Member Conyers, and thank my colleague, the gentlelady from Texas, Ms. Jackson-Lee, for your comments. It's very clear to all of us that today's cyber criminals present a new challenge to our law enforcement, to our prosecutors, and to our judges. It no longer takes a sophisticated cyber criminal to compromise personal and sensitive information from U.S. companies and from everyday Americans. To the contrary, criminals can easily obtain cyber exploit tools to create this havoc on the dark web. And with the increasing number of cyber attacks, it's vital that our state and local law enforcement, prosecutors, and judges be properly trained to protect the American people. For those reasons, I'm grateful for the opportunity today to introduce the Strengthening State and Local Cybercrime Fighting Act of 2015 to bolster state and local law enforcement efforts to fight cybercrime in this country. This bill will authorize the National Computer Forensics Institute, or NCFI, which was created in 2007 by the state of Alabama and which is currently operated by the United States Secret Service. Located in Hoover, Alabama, the NCFI is comprised of a 32,000 square foot facility which consists of classrooms, mock courtrooms, and an operational forensics laboratory. The NCFI has already garnered a reputation as the premier cybercrime training center in this nation, one that supports our state and local law enforcement investigators, prosecutors, and judicial officials. To date, as has been mentioned, the NCFI has already trained and equipped more than 4,500 local officials from all 50 states and from 3 U.S. territories. These NCFI graduates represent more than 1,500 agencies nationwide, including agencies from my congressional district, the 4th District of Texas, and law enforcement from Collin County and Hunt County and from the Greenville Police Department. Mr. Chairman, this bill gives men and women across this country the necessary tools and training that are needed to fight cyber criminals in the 21st century. So I thank you, Mr. Chairman, for bringing up this important legislation before us today, and with that I yield back.
Mr. Chairman,
For purposes, the gentleman from Michigan seek recognition.
to strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman and members of the committee. This substitute offered by our colleague from Texas removes references to assistance regarding terrorism in order to clarify that the National Computer Forensics Institute would not interfere with the traditional role of the FBI, which has jurisdiction over terrorism investigations and related training. And so I support this substitute amendment, which retains the important functions of NCFI in providing assistance to state and local enforcement with respect to cybercrime. The amendment does clarify an important jurisdictional matter between the Secret Service and the FBI. This will ensure that these agencies continue to provide the excellent services to state and local law enforcement consistent with their respective areas of expertise and jurisdiction. I support the substitute. Thank the chairman and yield back my time.
Chair thanks the gentleman and recognizing himself in support of the amendment in the nature of a substitute. I want to thank again the gentleman from Texas for his work on this bill and for these important technical changes. The amendment makes slight changes to the legislative text, and I support the amendment. The United States Secret Service, who will be implementing this bill, had a number of small technical corrections to the language, and I thank them for their help. I also applaud the gentleman from Texas for highlighting ways in which state and local law enforcement and federal agencies can work together on cybercrime issues. As I said, I support the amendment, and I urge my colleagues to do so as well. Are there amendments to the amendment in the nature of a substitute? For purpose, the gentleman from Texas seek recognition.
I'd like to strike the last word.
Gentleman is recognized for 5 minutes.
Let me join my colleagues, first of all, to indicate the importance of the FBI and U.S. Secret Service collaboration, but also the change that the gentleman from Texas made that helps clarify the issue dealing with references to threats or acts of terrorism. This amendment, the amendment in the nature of a substitute, removes these references. State and local enforcement training related to threats or acts of terrorism is absolutely critical and something that I know we all seriously value. However, because it is the FBI that has primary investigative responsibility on matters concerning terrorism, training in this area should and does funnel through the FBI. I am always a believer in making sure that we distinctively in this committee work with agencies and provide the best guidance to these agencies, as evidenced by my introducing of H.R. 48 that will assist the FBI and collaborate with agencies dealing with the issue of terrorism. And so I support the substitute, the amendment in the nature of a substitute, and ask my colleagues to support it. And I yield back.
Are there any amendments to the amendment? The question is on the amendment to the amendment in the nature of a substitute. Those in favor will say aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it. The amendment is agreed to. A reporting quorum being present, the question is on the motion to report the bill H.R. 3490 as amended favorably to the House. Those in favor will say aye. Aye. Those opposed, no. The ayes have it. The bill as amended is ordered reported favorably. Members will have 2 days to submit views, and without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 2745 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2745, to amend the Clayton Act and the Federal Trade Commission Act to provide that the Federal Trade Commission shall exercise authority with respect to mergers only under the Clayton Act and only in the same procedural manner as the Attorney General exercises such authority.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. In 1914, Congress passed the Federal Trade Commission Act, marking the beginning of a dual antitrust enforcement regime in the United States. Because both the Department of Justice and the FTC enforce our nation's antitrust laws, companies may and often do have different experiences when interacting with one agency relative to the other. One area in which the disparity can be most striking is in the merger review process. When a company wishes to merge with or purchase another company, it must notify both antitrust enforcement agencies of the proposed transaction. The DOJ and the FTC then determine which agency will be responsible for reviewing the transaction. As there are no fixed rules for making this determination, it can appear that the decision is made on the basis of a flip of a coin. There are two potential differences that companies can face based on the identity of the antitrust enforcement agency that reviews the company's proposed transaction. The first potential difference arises if the agency seeks to prevent the transaction by pursuing a preliminary injunction in federal court. There is a disparate legal standard applied to each antitrust enforcement agency when it requests a preliminary injunction. The second potential difference lies in the process available to each antitrust enforcement agency to prevent a transaction from proceeding. The FTC may pursue administrative litigation against a proposed transaction even after a court denies its preliminary injunction request. In contrast, the Department of Justice cannot pursue administrative litigation. There is no justification for these disparities in the merger review processes and standards. The Bipartisan Antitrust Modernization Commission recommended that Congress remove the disparities, and the bill before us today, the Standard Merger and Acquisition Reviews through Equal Rules Act of 2015, or the Smarter Act, does just that. I applaud Mr. Farenthold for introducing this important legislation that will enhance the transparency, predictability, and credibility of the antitrust merger review process. By enacting the Smarter Act into law, Congress will assure that companies no longer will be subjected to fundamentally different processes and standards based on the flip of a coin. Notably, the legislation has garnered the support of former and current FTC commissioners, including former Chairman David Clanton, former Commissioner Josh Wright, and sitting Commissioner Maureen Olhausen. The Smarter Act is an important step toward achieving this committee's goal of assuring that our nation's antitrust laws are enforced in a manner that is fair, consistent, and predictable. And I urge my colleagues to support this good government bill and yield back the balance of my time. I now recognize our ranking member, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Mr. Chairman and members of the committee. We've got a slight problem here. The Smarter Act would require the Federal Trade Commission to use the same merger enforcement procedures as the Justice Department's Antitrust Division for proposed mergers, acquisitions, joint ventures, and other similar transactions. But I think there may be some flaws in this if we check it out carefully. By weakening the Commission's independence, this bill undermines Congress's original intent in creating the Federal Trade Commission in the first place. For good reasons that are still relevant today, Congress established the Commission to be an independent administrative agency, and we must be mindful of these reasons as we consider the arguments in favor of the Smarter Act. Even though the Justice Department's Antitrust Enforcement Authority already existed at the time Congress created the Commission in 1914, Congress established this agency in direct response to the perceived inadequacy of existing mechanisms to stop the wave of mergers and corporate abuses that continued to occur 24 years after the Sherman Act's enactment. The Commission is an independent body of experts tasked with developing antitrust law and policy free from political influence and particularly executive branch interference. Congress specifically gave the Commission broad administrative powers to investigate and enforce laws to stop unfair methods of competition, as well as the authority to use an administrative adjudication process to help it develop policy expertise, rather than requiring the Commission to try cases before a generalist federal judge. Rather than strengthening the Commission's authority, the Smarter Act unfortunately does just the opposite. Of greatest concern is the Act's elimination of the administrative adjudication process for merger cases under Section 5B of the Federal Trade Commission Act. By doing so, the bill effectively transforms the Commission from an independent administrative agency into another competition enforcement agency indistinguishable from the Justice Department. The Commission's administrative authority is designed to serve its role as an independent administrative agency. Eliminating it, therefore, threatens the Commission's distinctive role and independence. Now, make no mistake, eliminating the Commission's administrative authority opens the door for the ultimate elimination of the Commission's role in competition and antitrust enforcement and policy development. And you don't have to just take my word for it. While supporting the bill's harmonization of preliminary injunction standards applicable to two antitrust enforcement agencies, former Republican Commission Chairman William Kovacic has already publicly said that the, and I quote, rest of the Smarter Act is rubbish, end quotation. Former Chairman Kovacic recognized the ultimate effect of the Smarter Act when he commented, "Let me put it this way, behind the rest of the Smarter Act is the fundamental question of whether you want the Federal Trade Commission involved in competition law." Similarly, current Commission Chairwoman Edith Ramirez observed last year that the bill would have far-reaching immediate effects and fundamentally alter the nature and function of the Commission, as well as the potential for significant unintended consequences. Consumers Union, the 79-year-old policy and advocacy arm of Consumer Reports, also opposes the Smarter Act. In its letter to the committee, Consumers Union said that the Smarter Act is not only completely unnecessary, but could create unintended hurdles to effective and sound enforcement and set the stage for further tinkering, both of which risk undermining what is now a coherent, consistent, well-established, familiar enforcement procedure within the Commission. Finally, the Smarter Act is problematic because it may apply to conduct well beyond larger mergers, which could further curtail the Commission's effectiveness. In particular, the Smarter Act would eliminate the Commission's authority to use administrative adjudications not just for the larger mergers, but for any proposed merger. It also removes such authority to review non-merger activity, like a joint venture or similar transaction. Now, I recognize that the bill's authors have tried in good faith to respond to some of the concerns expressed by me and by the Commission last year in response to an early draft of the Smarter Act, and I appreciate these efforts. Moreover, I recognize that the Commission itself earlier this year changed its procedural rules to make it easier to end the use of administrative litigation where it loses a preliminary injunction proceeding in court. My disagreement, however, is more fundamental, at least regarding whether the Commission should retain its administrative litigation authority at all in merger cases. This disagreement unfortunately leads me to oppose the Smarter Act even in its rewritten form, and so accordingly I urge my colleagues to carefully consider these arguments and oppose H.R. 2745. I thank the Chairman and return any unused time.
The Chair thanks the gentleman, and without objection, would ask that a letter from the United States Chamber of Commerce dated September 29, 2015, in support of this legislation, and a letter from 15 antitrust law professors be made a part of the record.
Mr. Chairman,
The gentleman from Michigan.
might I ask unanimous consent to enter into the record behind my statement 3 items: a letter from the Consumers Union, a letter from the Federal Trade Commission, Edith Ramirez, and an article entitled Kovacic, Smarter Act is Trash. For the record, please.
And notwithstanding the impolite phraseology used in the last title of that article, they will all be made a part of the record.
Thank you very much. That was not my comment. It was part of the title. Thank you.
And the Chair is now pleased to recognize the gentleman from Pennsylvania, Mr. Marino, Chairman of the Subcommittee on Regulatory Reform, Commercial and Antitrust Law, for his opening statement.
Thank you, Mr. Chairman. Merging companies must have certainty for how our antitrust agencies will review a proposed merger. It is only common sense that parties to a merger under review should not be subject to different standards of review and procedures solely because a particular merger is referred to one agency rather than another. Our antitrust review process should be subject to regular order in this fashion without respect to the merits of any underlying transaction. I am pleased that we are moving an important recommendation of the Antitrust Modernization Committee forward. I thank Chairman Goodlatte for bringing forward this bill, and I thank my colleague from Texas, Congressman Farenthold, the Vice Chairman of the Regulatory Reform, Commercial and Antitrust Law Subcommittee, for proposing it earlier this year. I have proudly co-sponsored it, and I urge my colleagues to support it as well, and I yield back the remainder of my time.
Thank you, Mr. Marino. I'd now like to recognize the gentleman from Georgia, Mr. Johnson, the ranking member of the Subcommittee on Regulatory Reform, Commercial and Antitrust Law, for his opening statement.
Thank you, Mr. Chairman. Congress first established the Federal Trade Commission in 1914 to safeguard consumers against anti-competitive behavior by specifically empowering the Commission with the authority to enforce, clarify, and develop antitrust law. Under the process of administrative litigation, also known as Part 3 litigation, the Commission may seek permanent injunctions in its own administrative court in addition to its ability to seek preliminary injunctions in federal district court. This additional authority is a unique mechanism that takes advantage of the Commission's longstanding expertise to develop some of the most complex issues in our antitrust law. The standard merger and acquisition reviews through Equal Rules, or the SMARTER Act, would create a uniform standard for preliminary injunctions in cases involving mergers, acquisitions, joint ventures, or similar transactions, and alarmingly, eliminate the Commission's century-old authority to administratively litigate these cases. Proponents of the SMARTER Act argue that divergent standards for enjoining mergers may undermine the public's trust in the efficient and fair outcome of merger cases. But it's unclear that these differences are material, let alone have led to divergent outcomes in merger cases. Indeed, for the 3% of transactions requiring second requests for information from the antitrust agencies, only about 1.5% of cases are stopped or modified. An even smaller percentage of these cases go to trial or an administrative hearing. We should hesitate before making wholesale changes to the law based on theoretical concerns involving about 1% of mergers, which also happen to be some of the largest and most consequential. In the absence of any evidence, it is difficult to support wholesale changes to longstanding antitrust practices at the FTC for consistency's sake only based on speculative harms. But even assuming that there are material differences in cases brought under these standards, we should strike a balance in favor of competition by lowering the burden of proof in cases brought by the Justice Department, not by raising the Commission's burden for obtaining preliminary injunctions. Courts already require a lower burden of proof in cases brought by the Commission and Justice Department precisely because both are expert agencies equipped with large staffs of economists that analyze numerous mergers on a regular basis and may only bring cases that are in the public interest. To the extent that we should address perceived differences in the standard for preliminary injunctions in merger cases, legislation should favor increased competition, not the interest of the merging parties. The SMARTER Act would also eliminate the FTC's authority to administratively litigate mergers and other transactions under Section 5B of the FTC Act. Leading authorities in antitrust across party lines have expressed serious reservations with eliminating the Commission's administrative litigation authority. For instance, Bob Kovacic, a former Republican chair of the Commission, has referred to this aspect of the bill as, quote, rubbish, noting that the Commission has used administrative litigation to win a string of novel antitrust cases that courts have ultimately upheld, where the, quote, Commission has had to fight for every single foot along the way, end quote. Edith Ramirez, the chairwoman of the FTC, likewise wrote last Congress that eliminating the FTC's administrative litigation authority would fundamentally alter the nature and function of the FTC, and I suppose that's what the true intent of this legislation is. I urge my colleagues to oppose this legislation, and I yield back.
Chair thanks the gentleman and recognizes the gentleman from Texas, the chief sponsor of the bill, Mr. Farenthold, for his opening statement.
Thank you very much, Mr. Chairman. In 2003, the bipartisan group of leading antitrust experts called the Antitrust Modernization Commission, or the AMC, took a look at how we can bring antitrust laws and enforcement practices into the 21st century. After an exhaustive 4-year review, the AMC issued a number of recommendations for congressional action. 2 of their recommendations dealt with how our nation's 2 different antitrust enforcement agencies, the Department of Justice, the DOJ, and the Federal Trade Commission, the FTC, review proposed merger transactions. The report concluded that the standards and processes used by the DOJ DOJ, and the FTC to prevent the consummation of a proposed merger inadvertently create an uneven playing field. Common sense states that there should be the same standard, or at least substantially similar standards, and the AMC agreed. These disparities should be removed because, in its words, parties to a proposed merger should have to receive comparable treatment and face similar burdens regardless of whether the FTC or DOJ reviews their merger. A divergence undermines the public trust that the antitrust agencies will review the transactions efficiently and fairly. More importantly, it creates the impression that the ultimate decision as to whether a merger may proceed depends in substantial part on which agency reviews the transaction. And that's the end of the quotation. To address this problem, I introduced the Standard Mergers and Acquisitions Review through Equal Rules Act of 2016, or the SMARTER Act, which incorporates the independent AMC's recommendation. This bill is nearly identical to the SMARTER Act of 2014, which was approved by this committee on a voice vote last Congress. It's simple, straightforward legislation that has two components. The first brings together the preliminary injunction standards that the DOJ and FTC must meet in court when they seek to block a merger. The second removes the FTC's ability to administratively litigate after a court denies the preliminary injunction request. Because the DOJ cannot conduct administrative litigation, it's unfair to some parties to face administrative litigation while others avoid it simply because they're not in front of the FTC but are in front of the DOJ. On two occasions, the Subcommittee on Regulatory Reform, Commercial and Antitrust Law held hearings on the SMARTER Act. These hearings left a clear congressional record. Antitrust experts broadly support making the preliminary injunction standard the same for both agencies and removing the FTC's ability to pursue administrative litigation with respect to proposed mergers. When businesses have to deal with the federal government, it's imperative that we ensure their treatment is predictable, fair, and transparent. The SMARTER Act accomplishes these goals by ensuring that companies will receive the same treatment regardless of which antitrust enforcement agency reviews its proposed transaction. To be clear, this bill does not and is not intended to make it easier or harder for a merger to be approved. As stated by the former chairman of the AMC, Deborah Garza, during the subcommittee hearing on the SMARTER Act, the idea here is not to change the merits or to change the number of transactions that on the merits get through or not. The whole idea is to simply make the process more transparent and clear and perceived as being fair. The SMARTER Act is common sense, straightforward, and developed through a robust bipartisan process. I urge my colleagues to support this bill and yield back the balance of my time.
Are there any amendments to H.R. 2745?
Mr. Chairman, I have an amendment at the desk.
The clerk will report the amendment offered by the gentleman from Texas.
Amendment to H.R. 2745, offered by Ms. Jackson Lee of Texas. Strike all after the enacting clause.
The gentlewoman is recognized for 5 minutes to explain her interesting amendment.
Thank you very much, Mr. Chairman, and I would certainly assume that everyone that presents legislation here is well-intended, but I would offer my concern for legislation that, in essence, even implodes the congressional intent for the Federal Trade Commission. This bill seeks to strip the FTC of its power by eliminating the agency's authority to enforce antitrust laws in larger merger cases and by blocking its ability to use its administrative proceedings to block a deal, even though it hasn't used this avenue since 2008. This change will require the FTC to use the same enforcement process as the antitrust division of the DOJ, thereby reducing the FTC's independence and undermining Congress' intent in creating an antitrust enforcement agency and policymaking body that will be shielded from political and particularly executive branch interference. Let me be very clear. When we talk of mergers and acquisitions, we are talking of consumers. That is the ultimate participant or benefactor or individuals that are impacted by the ultimate outcome of a merger or acquisition. So we take away the consumer's hand, the consumer's armor, by eliminating the FTC. In a letter by the chairwoman, as she indicated, the quasi-judicial role of the FTC is critical to our ability to fulfill our mission to promote competition and advance consumer welfare. It allows the Commission to conduct through hearings to develop both the facts and the law in a broad variety of antitrust matters. Our adjudicative function has been particularly valuable in complex areas such as hospital mergers, where the Commission has used the combination of the information gathering power and case-specific. Again, who are we representing here? The consumers. Yes, we want a balanced and even approach that deals with our businesses. We want the idea of the capitalistic system to work. But we know that in mergers and acquisitions, the little guy is lost in the crowd. In nearly 100 years, Chairwoman Ramirez says, the Commission has performed this role for almost 100 years, and it has fully realized the benefits Congress originally foresaw in 1914 when it created the FTC. And so, as she indicated, she is proud of the work that this agency has done, but so are many other. We have 2 Republican chairpersons of the FTC that are opposing this legislation. And let me just indicate to my colleagues, for my amendment indicates that we should start all over from this particular bill. For instance, in the past year, the FTC has challenged over 28 mergers, although in most it was able to negotiate a remedy to allow the merger to proceed. Just this past week, the consumer level in Texas, the FTC secured $82,000 settlement in an automobile dealer situation in violation of the Fair Crediting Reporting Act, different from a merger, but showing the work. Earlier this year, FTC ordered the largest divestiture ever in a supermarket merger, dealing with a number of supermarkets. Again, the FTC has also taken an aggressive stance on stopping anti-competitive mergers and conduct in the healthcare market by halting such practices. I'm holding in my hand an article that deals with the FTC returns money to consumers tricked into buying phony health insurance. Then we have the idea of separate investigations by the DOJ dealing with airlines. DOJ girds for strict review of any healthcare mergers, which indicates that there is some distinctive prospects for the DOJ and the FTC. Finally, Cephalon generics case with the FTC was settled for $1.2 billion. The little guy. And in this legislation that is called Smarter, all I can see is a gaping hole of, if you will, protection for our consumers. Why would we want to take away the armor or the additional protection for consumers who most likely don't have the individual capacity to appear before a federal court and deal with a grievance that is impacting thousands and millions? This is a big country. The FTC has done an excellent job. And as the chairwoman has recounted a long list of successes, you're now taking away, you're literally putting us in a trap door. Walk in the house, the consumer falls in the trap door, and the businesses stand on the outside looking. We need fairness, and this bill does not give the consumer fairness. I ask my colleagues to support the Jackson Lee amendment.
The chair recognizes himself in opposition to the amendment. The bill introduced by the gentleman from Texas, Mr. Farenthold, does not eliminate the FTC as was suggested by the gentlewoman from Texas. The bill does not eliminate the FTC's authority to proceed administratively on the type of consumer claims that the gentlewoman described in her statement. However, her amendment does eliminate the gentleman from Texas's bill. And as I've stated previously, I think this is a very good bill for all the reasons that I and others have outlined already, and I urge my colleagues to oppose this amendment. For what purpose, the gentleman from...
Would the gentleman yield? Would the chairman yield?
I'll be happy to yield to the gentleman.
Thank you. I won't use much time. Thank you, Mr. Chairman. I join you in opposition to stripping the bill for an important reason. Mergers are, by definition, a limited time opportunity, and the use of administrative law judges and the multiple bites at the apple that the FTC has the power to do denies the stockholders, the employees, and others a speedy adjudication in an Article III court if appropriate. So it is clear that Mr. Farenthold's legislation seeks what should be extremely bipartisan, and this committee should be totally in support of it. There's nothing wrong with saying the government has unlimited money to go into an Article III court and object to a merger. There is something wrong with using another bite at the apple at the FTC to, in fact, use an administrative law judge, not a constitutional judge per se, to thwart and delay mergers as a part of their strategy. So I join with the chairman and thank him for his leadership in opposing this amendment.
For what purpose the gentleman from Tennessee seek recognition?
Strike the last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. Concern I've got with this is basically coming to Washington and going home. And those of you who drive don't have that problem, but those of us who do know what the airline merger did to us. Now, my friend to my left, he likes it because I have to eat in the Atlanta airport on occasion and run through there and try to do my best O.J. Simpson impression and make the airplane. They do a terrible job of getting you a cart to help you get there if you got a difficulty in walking. You got to walk. The airlines came before our committees, and they said this will not affect the hubs in Memphis and Cincinnati. Well, not only did it affect them, it decimated them. Instead of having 320 flights a day by Delta in Memphis, we've got 28. And the airline industry merger has hurt the general public. Consumers were not considered. And I guarantee you, Stephen Anderson has never sat in those seats that aren't in the front cabin. They are miserable. And all the airlines have gotten that way. I don't want to take away any possibility of any agency doing right. Mr. Isis says that they ought to have something about getting another bite at the apple. They don't have enough vegans over there. They don't like biting apples. I think they're just munching on steak. Nobody's biting at the apple. They let these mergers go through and the consumer be damned. If you look at the committee that recommended this, it looks like a great committee. If you're in the Bar Association doing some type of special procedural rule on something real boring like the committee that Mr. Franks has, that I am the ranking member of the Democrat side, real boring procedural stuff. Not a single person on there with consumer in their background, all lawyers, all worked for some firm representing some business, all smart, but nobody with a consumer interest. Most of whom flying in and out of Washington, where you got air service. They're not flying in and out of Memphis or Shreveport or Huntsville or the Boot Hill of Missouri. It doesn't take them forever to get here. So I'm against taking away anything that gives somebody a bite at the apple to protect the consumer.
Would the gentleman yield?
The gentleman yields.
Thank you, and I thank my colleague. I certainly share your frustration because I'm part of a merger that was done under the Bush administration, but overseen by DOJ, just as your frustration does seem to come from the U.S. Air merger done under the Department of Justice in the Obama administration. I think we can have a serious talk about what the basis in antitrust is for them. The question here, though, in Mr. Farenthold's legislation deals with an administrative question and a second bite at the apple. Oddly enough, these airlines would have and did go through DOJ and were approved, and maybe they have not served the consumer well. I don't want to upset the airline I have to fly with as much as you seem to be willing to. So I won't go quite as far on the service. But I do share with the gentleman that we should not rubber stamp these. At the same time, isn't this a committee who believes that a process that includes a federal judge ultimately should be the fairest process? The question is DOJ arguing hard enough, and is the Federal Trade Commission being listened to? Not, is the Federal Trade Commission allowed to run it through an administrative law judge that ultimately then gets appealed back to that federal judge? I think that's where we agree on the concerns. I think we disagree on the administrative part that Mr. Farenthold seeks to fix. And I thank the gentleman for yielding.
Would the gentleman from Tennessee yield?
Yes, I will.
I thank the gentleman for yielding. Just for a point of clarification, virtually all airline mergers go through the Department of Justice because of jurisdictional limitations on what the FTC can do in that area. So the gentleman's concern may be well taken, but it is not well taken with regard to this bill.
Yes, sir. My concern is weakening antitrust enforcement at all. I would like to see something. This committee has had the proposal that all rules and regulations go through this committee, and if this committee and the Congress don't approve them, they don't go into effect. I think all mergers ought to go through this committee, and if the Congress doesn't approve them, they shouldn't go into effect. The consumer needs a voice, and the consumer doesn't have a voice. It certainly doesn't have an ear. Thank you.
Well, the gentleman is free to introduce just such legislation.
Well, get a hearing and a vote?
We'll look at the legislation first.
Mr. Chairman,
For purposes, the gentlewoman from Texas has already been recognized on her amendment. Does the gentlewoman wish to withdraw her amendment?
if I could get some time, Mr. Chairman.
Well, another member could. What purpose the gentleman from California?
Strike the last word, and I would be happy to yield to my colleague from
Gentleman from
Texas.
California is recognized for 5
I will
minutes.
join Mr. Cohen, Mr. Johnson, and others on that legislation that he's offered. And, Mr. Chairman, I know that we will get a final vote on this bill, but let me, as I intend to act on my amendment, emphasize that the FTC exists to ensure fair competition and prevent enormous concentration of economic power that hurts customers and small businesses. I remind my colleagues that it's the consumer that is lost in the crowd, and the two bites at the apple, with the FTC being the discoverer, is the way the system has worked. This bill is a wrong direction. I hope that we will be able to do something on the way to the floor, and I ask my colleagues, I thank them for their indulgence. At this time, I'll ask unanimous consent I'll ask unanimous consent to withdraw my amendment.
Without objection, the gentleman's amendment is withdrawn. Are there any other amendments to H.R. 2745? Being none, a reporting quorum being present, the question is on the motion to report the bill H.R. 2745 favorably to the House. Those in favor will say aye.
Aye.
Aye. Those opposed, no.
No.
The ayes have it, and the bill is ordered reported favorably. A recorded vote has been requested, and the clerk will call the roll.
Mr. Goodlatte?
Aye.
Mr. Goodlatte votes aye. Mr. Sensenbrenner? Mr. Smith? Mr. Shabbat? Mr. Shabbat votes aye. Mr. Isa? Mr. Isa votes yes. Mr. Forbes? Mr. King? Mr. King votes aye. Mr. Franks? Mr. Franks votes aye. Mr. Gomert? Mr. Gomert votes aye. Mr. Jordan? Mr. Poe? Mr. Poe votes yes. Mr. Chaffetz? Mr. Chaffetz votes aye. Mr. Marino? Mr. Marino votes yes. Mr. Gowdy? Mr. Labrador? Mr. Farenthold?
Aye.
Mr. Farenthold votes aye. Mr. Collins? Mr. Collins votes aye. Mr. DeSantis? Ms. Walters? Ms. Walters votes aye. Mr. Buck? Mr. Buck votes aye. Mr. Ratcliffe? Mr. Ratcliffe votes yes. Mr. Trott? Mr. Trott votes yes. Mr. Bishop? Mr. Bishop votes yes. Mr. Conyers?
No.
Mr. Conyers votes no. Mr. Nadler? Ms. Lofgren?
No.
Ms. Lofgren votes no. Ms. Jackson Lee?
No.
Ms. Jackson Lee votes no. Mr. Cohen? Mr. Cohen votes no. Mr. Johnson votes no. Mr. Pierluisi? Ms. Chu votes no. Mr. Deutsch? Mr. Gutierrez votes no. Ms. Bass? Mr. Richmond? Ms. Delbene votes no. Mr. Jeffries votes no. Mr. Cicilline? Mr. Peters votes aye.
Has every member voted who wishes to vote?
Who? Mr. Chairman, how am I recorded?
The gentlewoman is recorded as no. Does the gentlewoman have a unanimous consent request?
Thank you, Mr. Chairman. I ask unanimous consent to place in the record an article, FTC returns money to consumers tricked into buying phony health insurance, and Cephalon Generics case with FTC settled for $1.2 billion.
The objection, they will be made a part of the record. Gentleman from Virginia.
Mr. Forbes votes yes.
Is he coming?
Has every member voted who wishes to vote?
How you recording?
Mr. Chairman, how am I
The gentleman from
recorded?
Georgia seek recognition. The gentleman from Georgia is recorded as no.
Okay, Mr. Chairman, and I neglected to inquire whether or not the letter from I got to the hearing just a bit late.
The gentleman might suspend so we can take the vote from the gentleman from Rhode Island.
Mr. Cicilline votes no.
Mr. Chairman, I'd yield back.
The chair thanks the gentleman, and the clerk will report.
Good, Johnson.
Thank you.
Mr. Chairman, 18 members voted aye, 10 members voted no.
The ayes have it. The bill is reported. It's ordered reported favorably to the House. Members will have 2 days to submit views. This concludes our business for today. Thanks to all of our members for attending, and the markup is adjourned.
Thank you, sir.
Thank you.